Judge, we just got through talking about Dean McMahon. I wanted to ask you about some of the other professors at the law school. Dean Hebert, and what you recall about him.
Dean Hebert was just something special. As you know, he graduated from law school and very shortly became a dean, I think, down at Loyola. Started teaching there, and then we had bad things happening at the law school in Baton Rouge, and they brought Dean Hebert in. And he became, as a very young man, he became dean, and he stayed dean till after I graduated. Just about the time, because he didn't sign my certificate in '59, but about '58 he finally retired. He had gone back into the practice a time or two, but he always came back to law school.
Do I recall right that Dean Hebert participated in the Nuremberg trials?
He was a prosecutor in the Nuremberg trials. He went into service during the war, and he had, of course, already been dean, and he went into service, and he was in the military corps, by whatever name it was then known as. And then when we put together the team for the prosecutions at Nuremberg, he was one of the prosecutors.
Did you ever talk to the law students about his experience?
Very little. That was one of and I can't give you the reason. I'm sure that one could meditate and think of the reasons, but he was very quiet about. He would answer questions politely, but he had nothing to it. He never took it as an opportunity to make a speech or to tell anything. That was a very trying time, obviously, for him. This was new stuff they were doing. But I had the feeling that the bottom line was that he was satisfied that what was done fairly. And with very little, we civilians like to turn to the written law. And what's the first article of the code? Law is a solemn expression of the legislative will. I think we've amended that now to add something about judges' decisions. But law is a solemn expression of the legislative will. It's just to a civilian. Common law lawyers, they want to look to a rule. Sometimes they got to pull it out of the air, but want a rule. And so you want to look to something. Well, there was no civil law that you could really turn to. There was no common law that you could really turn to, as I understood it, in order to put together what became the basis of the Nuremberg trials and the charges that were made, the violations that they were charged with, and their performances, those that were the defendants. And they had to put that together, and it was quite a challenge for them.
Law school, what was your academic standing the year you graduated?
I passed, and I was on law review, and I guess I was up in the top 3 or 4% of the class. I think the top of the class was Fred Ellis.
Foggy Freddie.
He was so smart he scared you. He taught later. He may have taught you.
He was adjunct at the law school, but I never had him.
Adjunct. He died awful young. But we would talk. I never understood what he was saying half the time because he was so darn smart. He was tossing our class. Had some smart people in my class, and I was fortunate enough to be up amongst them. Some of the top ones.
Was Professor Murray a classmate?
Yes, sir. He's a smart dude.
Smart dude. He types real fast.
Oh, he could do it with a sissy. You had to be a sissy to type, okay? In my day. Boys didn't type, girls typed. And so here we go. Here comes Frank Murray. We got our first exam. And he asked the professor, because he got such a terrible handwriting, he asked the professor if he could type the answers. Well, now, the professor's got alerted to that, a boy who wants to type. So but Frank was working for the PR department across campus for the athletic department, the PR guy for the athletic department. I had a good job. He's working 40 hours a week. Had a better job than mine. I had to go to different places to get 40 hours. And he typed. And I had heard he did 123, 126 words a minute, which is pretty fast, I'm told. So the professor, okay, yielded, but said he would have to sit there in the classroom right next to where we were going to be taking the exam, which was an empty classroom for that period, right there in the doorway, would set himself up so that the professor could kind of keep an eye on him. I think he didn't say all those things, but that certainly went through my mind. And so you got to watch that boy who said he's going to type. I'll be over there reading the books, getting them answers. And so we got the question. And that first question was a dilly, was a half a page long. And all of us are sitting there just reading and reading, trying to figure out what the question is. Some of us may have had a pencil or a ballpoint and maybe wrote a few words down on a paper, kind of get the roughness out of trying to put down what it said. All of a sudden we hear next door, da-da-da-da, bang, da-da-da-da, bang, da-da-da-da, bang. We looked at each other. He is a goner. That dude is sitting over there typing that answer so quick we couldn't even finish reading the question. He goes, da-da-da-da, bang. You know, it was electric typewriter, you know. And said, he is a goner, man. He's out of here. Who is that boy? That Murray. Tore him up, too. Tore him up.
What position did you hold on the law review?
I did, because I was working full-time, I couldn't take on the editorial position during the regular school year, but I was the editor in the summertime. So I always say I was an editor of the law review, but I wasn't a member of the editorial staff during the regular school year.
How did you pay your way through law school?
Well, I got $150 a month from the government, and that helped. Of course, by the time I finished, we had 4 children, so it wasn't quite enough. I had a job at a grocery store that I worked at, and I had a job at finally in my last year and a half, I clerked at the Attorney General's office, and that was really neat. Because it was easy and it was fun and it was connected with the law, and I got like $100. Pretty good, buddy. Pretty good. And then I also, in addition to that, I had odd jobs. I'd pick up a few bucks a day.
During your time at law school, did you do anything outside of law school, extracurricular activities?
Like? Wasn't much time. By the time you'd gone to school and had classes and then done law review. Law review was very time consuming. And then we didn't get any, because we were in law review, if you remember, they may have changed that. You didn't get a chance to do any moot court. And we complained, maybe the wrong word, we brought our concern to the attention of folks at the law school about, look, we don't get a chance to do anything actually like in the courtroom like the others are doing. And so we put in, I forget what name we gave to it, but a moot court operation for members of the law review and others who want to participate so we could get some trial experience. And we did that, and I was very much involved in that, and matter of fact, tried a case or two. We'd bring some students from across campus, all pretty girls, and they would be our jurors and witnesses, and it worked very nicely.
Did you have a chance to pursue your interest in politics or government while you were in law school?
Yeah, but quietly, you see, because during law school we had a campaign for governor, and I was the this was just before I started, or just at the beginning of law school. This was right at the beginning of law school, 1956 election, and I was a statewide coordinator of students for Morrison Barham. Morrison was former governor of New Orleans and had run for mayor several times. He later became an ambassador was he ambassador to Central and South America? He was ambassador, shame on me, during the Kennedy administration.
I remember, but
It wasn't, maybe it wasn't, what's our organization that we have for Central and South America? It's a shame on both of us, there's a name for it. But he was ambassador to that.
OAS, Organization of American States.
It may be the OAS. That may be right. But he was ambassador then. But he ran for governor, and there was about, 12 of them. There was a bunch of people running. And my task was to go to all the campuses and get people on all the campuses, organize students from Morrison Barham. Morrison was, of course, later Ambassador Morrison, former Mayor Morrison. The Barham was Senator Barham from Ruston, the father of a classmate of mine who later became Senator Barham. And he was well regarded. And he ran as tickets then. There was a governor and lieutenant governor. So Morrison and Barham ran together, North Louisiana, South Louisiana. And boy, we'll win this thing. And I persuaded Mr. Harry that we ought to support him. And Mr. Harry was being pushed by supporters of a young fellow named McKithen. And I said, Mr. Harry, Morrison can win this thing. And so first primary, 43% of the vote. Morrison Barham, buddy. Ha, ha, ha. And the next in line was McKithen. He had 26, 27, somewhere in the 20s. Ha, ha, ha. Tick that on. We going down the road. Shucks. McKithen went around saying, won't you help me? Won't you help me? And he beat the devil out of Morrison Barham and became governor. Yeah, I had some experience, but I wasn't very successful. So I had to come up here and be with Mr. Harry, and he taught me better, you see.
By the time you finished your tour at law school, did you have a feel for what type of lawyer you wanted to be?
I wanted to be a trial lawyer. Wanted to be a trial lawyer. Wasn't sure whether I wanted to do what, because I didn't have enough of a feel for the totality of it. Obviously, that took years. But I knew I wanted to be in the courtroom. I didn't want to be an office lawyer. I didn't want to be a lawyer who worked just with papers, whether they were at the courtroom doing title searches and so on, or just working with contracts. And I didn't know that I wanted to be a lawyer who just represented people in disputes. I wanted to be representing them in a dispute with the setting courtroom. And that much I knew. And that's why I had several offers. I was very lucky when I finished law school. Dean Mack being largely responsible, but others as well, helping. I had offers in New Orleans and in Lafayette and in Shreveport and other places outside the state as well, and with the government. But I accepted the offer from Booth Lockett Jack Pleasant, soon to be called Booth Lockett Jack Pleasant of the Sage. The day I joined, they changed the name. And they were a trial firm. That's what they did. And I said, this is for me. I'm going to come up here and spend 2-3 years and learn how to be a trial lawyer and then get my butt down back to South Louisiana where I belong and practice law in Baton Rouge or Lafayette or somewhere down there. But it didn't quite work that way.
At the time you got out of law school, was it even remotely contemplated by you that you might end up being a judge on any court?
No. That really did not cross my mind. No. And I, of course, very actively involved in elections for judges, state court and city. You don't like federal judges, obviously. And had nothing to do with federal. That was Judge Ben Dawkins was already in place. Judge Hunter, who's still alive and still functioning, and a marvelous, marvelous human being and judge, was still very active. Was very active. Not still, was very active. And so, no, as time wore on, and I was bumped as well, I'd like to be considered for a judgeship, a federal judgeship, and I said no to that. I want to just stay right where I am as a trial lawyer until this thing came along.
Judge, I've just about drawn to the end of my questions, but I want to say that all the people who have inspired you will be proud of what you've become, and I think you have become what they encourage you to become. And we love you.
I'd like to think that's so.
It is so. Never doubt it for a moment.
Thank you.
Well, I'm Neil Kravitz. I was fortunate enough to be Judge Politz's law clerk in 1983 to 1984. I just want to say it's a great honor, Judge, to have been asked to come down and talk to you today. Particularly since the subject is your legal career, because your legal career has been just a very significant model for me as I've tried to follow in your footsteps to the extent possible. So it's really a great honor and pleasure to get to ask you some questions about your legal career here today. Let me begin by asking you, when did you graduate from law school?
Graduated, Neil, and in response to what you said, I'm very pleased that you're here. You've long been one of my favorite former law clerks. I'm glad to see you even got an honorable job so far. They made you a judge, and they got you on the payroll, and I'm proud of that. I graduated from LSU Law School on 30th of January 1959, and I went to work the next morning for Booth Lockett, Jack Pleasant, and the Sage in Shreveport. No, not the next morning, because the next morning was a Saturday, Sunday. On Monday, I went to work for Booth Lockett here in Shreveport.
How'd you choose that job?
Well, Dean Henry George McMahon was sort of looking out after me for various reasons. One being, of course, he was just a kind guy. And he also, because he knew I had 4 children and needed to get to work. And also because he had a better feel for what it was I wanted to do than I think I did at the time. He was there at the law school, and he arranged for me to be interviewed with several people. I had interviews in a number of places, Houston and Dallas and New Orleans and Lafayette, Baton Rouge. And then he arranged an interview for me with the firm of Booth Lockett, Jack Pleasant, as it was known then. The day I went to work, it became known as Booth Lockett, Jack Pleasant, and LeSage. Joe became a partner. And of all of the firms that I spoke to, and from very large firm settings to 2 or 3 lawyer settings, the one that had the biggest reality of a trial work was Booth Lockett, because that's what they did. They did some title work, they did some contract work, they did some of the things that lawyers do typically, but what they did was try cases, civil and criminal, and I had decided that I wanted to be a trial lawyer. I thought, and this was then I was going to come here and spend about a year, 2 or 3 at Shreveport, learn how to be a trial lawyer, and I was going to get myself back down to South Louisiana, where people, I won't come up with these Yankees in North Louisiana, and get back down to Baton Rouge or Lafayette, someplace, not New Orleans, someplace in South Louisiana and practice trial law, but didn't quite happen that way.
How many lawyers were in the firm?
It was Harry Booth, Leonard Lockett, Whitfield Jack, John O. Pleasant, and Joe LeSage were the partners, and John Carpenter was an associate, and me. That's what it started out with. It later grew to 12 when I became, many years later, the managing partner. It was 12.
Did the work at the firm meet your expectations?
Oh, and that plus, because I didn't hit the ground good, and they had me in court, and giving me, well, I know things that they were expecting to lose, looking back. I remember one of the very early ones, it was a loser, man. And I think the judge felt very sorry for me. I don't know what it was, but we put the case on, and I won. Wow. So I came back, and people think this is a joke. I came back, and Mr. Lockett said, "How'd it go, Hank?" I said, "Justice prevailed." He said, "Don't take it lying down, appeal." and they think that made that up as a joke. That's what he told me. and then right away they did, and got me involved in civil and criminal cases, state and federal. They had the broadest trial practice in this part of the country. It was just a group of just superb trial lawyers, both before juries and before judges, trial and appellate. I mean, it just was. It couldn't have been more perfectly designed, without me knowing, to fit what I in part knew I'd like to do, and I didn't yet know what I'd like to do. But I found myself in a trial firm, and boy, we hit the ground running, and they had me doing things, and we were going after it from the very beginning.
When you look back on your years working with those lawyers in that firm, what do you think you learned from them the most?
Be honorable, so that in any situation, the people who know you will say, "He said that, it's so," or "He has every reason to believe it's so." Be honorable and be firm. Don't let anybody flush you or run you. Measure your position for your client. Tell your client what you have and why you think you should do or not do whatever it is that's being recommended, and plant your feet and go. And if the trial judge misses it, there are courts of appeals. If the Court of Appeals misses it, you can try for the Supreme Court.
Did you specialize in any particular type of cases?
Gosh, that's a good question, Neil. It's a good question. I'd have to say yes and no to that. Some things I ended up doing all of it for the firm not by choice, like wage and hour. We had a wage and hour case in federal court early on, and Mr. Harry called me in, and he didn't know anything about wage and hour, and had no intention of learning, and said, Hank, check this out, and let's see what we got, and I did. I said, I didn't take a course in wage and hour. He said, take a day or two and study what you got to do. And I said, yes, sir. So I spent the next couple of days reading everything I could about the wage and hour law, and there were a lot of good writings on it. And I found out it was complex as it seemed, and it had a lot of complex, nice issues in it. It wasn't that difficult. And so I did that, and then as things happened, I then became the wage and hour man for the firm. And then that because I was trying cases, and the people at the wage and hour office knew me because I was there so often, and I became one who, in the area known as knowing about wage and hour. I was put at you then. I didn't do that on purpose. But then in other fields, in those days, the early days, we had no legal aid society. The judges would appoint someone. And in cases, Louisiana was way ahead of the rest of, or most of the rest, if not all of the rest of the country, in terms of the appointment of lawyers. The Supreme Court had not yet spoken to this issue. But under the Louisiana practice, if you were charged with a felony, you got a lawyer. I don't know if that's in the code or what. I never have looked it up. But it certainly was, it was written in stone. And I think they went over there. I was on salary the first couple of years. And they said, point the boy to some cases. Give him a little experience. Well, the judges were glad of that. So I had just a parade of assignments of cases from the mildly serious felonies to the death penalty cases. You couldn't under the Louisiana law at the time, you had to have 5 years of experience before they could put you as the lead lawyer in a death case. But gosh almighty, I can remember in that first 5 years, I was the second lawyer when they had a lead lawyer who had 10, 15 years experience, all civil, who didn't know what he was doing in the courtroom, and quickly made it known to me and said, I don't do this. I was the second lawyer because I didn't have my 5 years, and handling capital cases, which have always been the toughest case for me as a lawyer and the toughest case for me as a judge.
What did you think of doing court-appointed cases for indigent people?
Enjoyed it. They had some pluses in it. Invariably, the client would figure, I don't have a chance. I can't hire a lawyer. I'm going to go in there. I'm not going to know what's happening. I didn't do this, or I didn't do it as bad as it seems. Or I did do it. And I'm going to have the sky falling on me. And then have a lawyer come in there and stand by their side, and it somewheres along the way, some it went all the way to the end before they realized it. I remember one death penalty client telling me, thank you so very much, I didn't have any idea that you were really on my side that hard and you would fight so hard for me. God almighty. And but that, and maybe it's a selfish thing. I've wondered about that to myself over the years, why I took such enjoyment and pride out of it. Because you stand there with them and you say, you're going to get to the fair break. The law is going to be observed, and if you're innocent, they're going to have to prove you're guilty, and we're going to see that they prove it right. If you're guilty, we're going to put it in the context, well, the best possible light in terms of what the judge does by way of punishment. And to do that, I just took a great deal of satisfaction and pleasure out of it. I'm not sure how that sounds. It sounds like you're some kind of kook. But I looking back on it, I still feel that way.
I know during the years that you were at the firm, there was a lot of civil rights litigation going on in the Deep South, including Louisiana. Were you involved in any of that?
Yes.
What kind of civil rights litigation were you working on?
Integration of schools, integration of, and interestingly enough, the biggest case on integration of schools that we handled was, by that time, Judge Pleasant had become the attorney for the school board in the late 60s, and so we had this.
Had he been a judge before?
Had he been a judge? Yeah, he had, Judge John R. Pleasant, he had been a district judge here in Caddo Parish just before the war started, World War II, World War II, yeah. And then he went into service, and he was a judge a year or two. He went into service, and he served, I guess, about 4 years. Came back out of the service. He was, of course, married and had 2 children, and he went back to being a judge for a year or so, and then decided, man, he could do anything and make more money than being a judge. What to pay for judges was in the 40s, I'm telling you, it was fierce. And so he went into private practice. But once you've been a judge, there's a tradition of always calling you judge.
Right.
I don't know if it's just here in this part of the country or if it's all over the country.
I think it's everywhere.
Yeah, I guess that's right. And so John Pleasant was always Judge Pleasant to us. And he was attorney for the school board. And so I was doing trial work, and he said, got this little problem with the school board. What is it? Integration and racism, and I'm defending it. I said, God, I'm going to do this, Judge. And he said, do right. And we did right. We ended up with a stipulated judgment and the schools. But we had those civil rights cases, and they were I guess you'd call them, they would fall in the general category of civil rights cases, reapportionment cases, where the reapportionments were done. I did some as a lawyer, and I think the one that I enjoyed most, by that time I was wearing the robe in the early 80s. By the time you clerked.
I think, actually, yeah, I remember.
The New Orleans case was when you were here.
Kathy Dixon was working on it when I arrived. She'd been working on it for many
Just
months
wrapping it
before
up.
then. Right.
Where they had redistricted New Orleans, and we had a 3-judge court, 3-judge trial court that I chaired with 2 district judges.
Yeah, I remember you and Kathy were spending hours going over and over the drafts of that.
Hours and hours. And when we had that drawing of Orleans and the way they had done their business, and they had reached over and pulled into one district, and pushed in, and when you drew the line, it was a perfect head of a duck. We called it the duck case. And we ordered the state of Louisiana. I mentioned this in talking a little bit ago with one of your colleagues. It's a reported case. We ordered the state of Louisiana to reapportion New Orleans consistent with the law, and gave them a time to do it, and gave them plenty of time, because it was going to be the election for Congress the next year. This was in the fall, and gave them to the end of January or something like that. And so they met, called the legislative session in December, got together, and they did their business right. And they reapportioned it the way it should have been reapportioned. And we found out in the trial of that case that both houses had agreed on a reapportionment plan. Found it out later, withdrawing the lines. And they were going to take it up in the 2 houses. There was going to be no real opposition to it. It was fair, it was proper, it was consistent with the law. The lawyers had told them what the law was and what it required, and they followed it. And they got in there, the governor and some of his leaders got in there, and they got to mumbling about it and come out of there saying, we can't do that, we've got to... And somebody decided they were going to not have any majority black districts in New Orleans, and so they redid it and passed that. And so we just told them, do it the way it should be done, and gave them a time limit to do it. If you have not done it by the end of whatever, January, February, then we would resume court on that week, and we would put in a plan. Well, there was never enough said for us to resume court, because in December they got together and they reapportioned and they followed. I believe they put that plan in that was approved, or close enough to it. Fine plan, fair, constitutional, legal. And I got a letter from the governor's lawyer, handwritten note, not a letter, handwritten note. Dear Judge, just thought I'd tell you we've now passed Act so-and-so. You'll find it totally consistent with the law, period. While we were here, we thought we would raise your taxes, period, signed by the lawyer. And they had. They raised, one of the things they did at that session was they passed that reapportionment, and they raised the income tax. Well, just a little bit, but they raised it. We thought we raised your taxes.
Now, you also did, when you were practicing, you did a lot of personal injury cases.
Yes, great deal.
What was it like to be a PI lawyer or a plaintiff's lawyer in Louisiana back in that time, and what did you enjoy about that work?
Again, what I said before, people have been hurt, injured, they were out. And it's an exception. Some were not really in trouble, but invariably, the reality was that they were financially and really in a bind because they were not able to work. They had these expenses and so on. They had their losses, whatever the losses were, whether it was a death, whether it was an injury, and you're trying to make it whole. There was a satisfaction in being able to assist them. Most were settled, and assist them in resolving it. Good thing we do settle because the courts couldn't handle all the cases if we didn't settle 90% plus of them. But every now and then you wouldn't. You'd have one, boy, the loss was there. No question about that. The liability was a question of you couldn't prove it. So you couldn't settle it and you'd lose it. And that hurt. It shouldn't hurt. You'd say, well, you did your best, but it hurt. But fortunately, it didn't happen. It didn't happen enough to make you want to quit doing it. And there was a satisfaction in that. Did some domestic work. I tried to stay away from it, but did more than a little bit. Disputes over custody of children, we didn't have quite as many then as we have now. Those were always particularly gut twisting because I had all the children, and whether I represented the wife or the husband, I had children, and the idea of not being with my children or not being able to visit with them, or a limitation on those ties, that always strained. But in the main, it was a practice that I very much enjoyed.
I know one of the things that we always talked about a lot while I was clerking, and that we've talked about a lot since, is how important you think it is that people of all socioeconomic, all parts of the socioeconomic stratus kind of have access to lawyers and fair access to the legal process and the legal system. And I know you were greatly involved as a lawyer or in dealing with legal services for the poor and for the middle class. You want to talk a little bit about those efforts?
Yeah, indeed, because what you're saying is quite true. When I came here in '59, we had the Bar Association had been aware of this and had sought to do something about providing legal services for those who could not afford. In the criminal area, as I mentioned, Louisiana Civil Code took care of that, and you were covered. There'd be a appointment, not for misdemeanors, but for felonies, but not civilly. And there's so very many things that are taken into court civilly. Little things to large things. Putting the tenant being put out by the landlord, or not being paid what you're owed because they figured you really can't bucket too hard and make them pay. I mean, it's all of the things where people were being taken advantage of, or it looked like they were being taken advantage of. Having a lawyer for it because there was enough involved. And so the Bar Association of Shreveport, I'm very proud to say, had, before I got up here, addressed that problem, and they had an office that was known as the Legal Aid Office, where we had one lawyer and one secretary, and they were paid next to nothing. And I remember looking at the stuff, the Bar Association had a little committee that oversaw it, and the president of the bar in my first or second year, at the most third year of practice, knew I was active in trial work and put me on that committee as chair. And so I got very familiar immediately with what they were doing. It was mostly a little domestic work. And I looked at those numbers. It was outrageous. Like 2,100. Well, no one person can handle 2,100. We thought the national, a useful national average figure of 700 claims was high. Somewhere between 500 and 700 would be an appropriate number for a lawyer to handle when you're talking about having the interviews and making a decision and going forward if there's litigation. No, that whole bit. And that seems like, that's a full load. But 2,100. And so we looked at what we had and said, how can we expand it? And that fell our task. That was probably the first challenge I took in terms of, other than just my straight practice, trial practice. And we spent the better part of a year or so looking to see how we could increase the the money that we were receiving, what little we were getting, not even $1,000 a month from the local agency that did the funding for the area. And the board put up a little bit, but a modest nothing amount in a very real sense. And so we started doing that and figuring out what he would need. And fortunately, along comes the war on poverty. And said, holy mackerel, look at here. In the meantime, we beefed up the office and got a second lawyer by hook or crook and begging. But now the war on poverty. And funds for this was built into this. Wait, look at here. And so we quickly put together a program for legal services for the poor and got the information we could get from Washington, and there was not a whole lot to be gotten, but got that together, put a package together, sent it to them. They asked for some more stuff, sent it to them, and they blessed over it. And the next thing we knew, well, from that $11,000 that we had for an annual, they approved something like $52,000. Wow. Golly! And we got, what? You know, just like that. And said, yay, man. And they sent it to the governor. And the governor was, when I said McKithen by that time, sent it to the governor of McKithen but for us. There was no problem. I mean, the governor was certainly going to accommodate that. They got this federal money and talked to his lawyer and sent it to us. And so we expanded the office and went to 4 or 5 lawyers and were able to expand the services. And so services for prepaid services for the poor. And so the Caddo Bossier prepaid legal services operation now is Northwest Louisiana prepaid legal services operation. And I can't tell you how many lawyers involved in it. Right. One of my sons is on the board. Bennett's on the board. Proud of that. Yeah, we did that, and that's taken us through the 60s. We're getting toward the end of that, and we're finishing that program. I was proud of it. It's in place and it's working. But in the process of doing that, we realized, you know, we've been concentrating on this, but what came forcefully to our attention was there are people who don't qualify for those services, who are making a little bit of money, enough to, or almost enough to take care of themselves and their family, but can't handle the expenses of a legal problem that comes down the pike. And so we got to agitating over that and said, listen, look, the very rich can take care of themselves. The very poor, well, we got something in place. What are all these poor devils in the middle? Yeah. Can't that be something? And so that inquiry then grew, and we started agitating over, could we put together some kind of thing like some kind of insurance program or something. And about that time, the American Bar Association made known that they would like to examine into the possibility of providing the mechanism and or finances for taking care of the expenses of legal services for the people who do not qualify and who are not up here with the extra funds to do it. And I said, holy mackerel. Well, we had just changed, we're now late 60s. We had just changed president of the bar, and I was on, the incoming president said, will you serve? I said, man, I got to get back to practicing law. I've been doing all these things, and my firm's going to run me off. And he said, well, I'd like to have you on the board and have your counsel and advice, but you got to be a chairman of a committee. He said, I want you to take over the Bar Activities Committee, I think. I may be halfway making up the name, but it sounded like that. And I said, what does it do? He said, don't do nothing, but you be chairman and you'll be on. I said, well, I go for that. I don't have to do nothing. Yeah, sure. And so I got a notice it's going to be a board meeting. I was trying a case over there that day. Not unusual, almost every day. And meeting was at like, 5 o'clock, and at 4:30, end of the workday. And I trying this case, and we thought we'd finish, and I looked down, I said, not going to finish, and looks like we were going to continue to the end of the day, and sometime the judge had run a little past 5, and they thought they could finish it around 5:30, so, and I knew this wasn't going to finish, and I asked the lawyer to go up, and I asked the judge, wonderful Judge Flanagan, just a good old gentleman, Judge, It's the first meeting of the board for the Bar Association, and Bob McElgee had just been elected president. I'm on the board, and he was anxious for me to be there, and I wonder if we perhaps might recess. We can't finish today, and he looked at the other lawyer, and so he said, fine, let's do that. So we recessed court, and I hustle over to the meeting. Okay, we do the business to wrap up one point. You know how that goes. It'll take about a few minutes, and judge excused everybody, told them when to report the next morning, and zip. And I get my gear and I scoot back over here to Bob's office, and I go upstairs and apologize for being late and get myself a cup of coffee and go sit down, and they're finished discussing something. And I just push it aside, doing nothing with it. And I missed it. And so they go, done anything? No, we made no affirmative decision. So, and I pulled that letter over, and I saw it from the American Bar Association. And I looked at it. I said, what'd you do, Mr. Chan, what'd you do with this? He said, we decided we're not going to do nothing with it. I said, it's from the American Bar Association. Least we can do is answer it. He said, I'll assign it to your committee for activities appropriate. You prepare an answer. So I look at what it was an inquiry from the American Bar Association. We want to look into this possibility of providing some methodology for services for middle-income Americans, and wonder if your bar association might volunteer to do a program. And so before the end of that meeting, I said, come on, why don't we volunteer? He said, fine, volunteer. And so I wrote a letter and volunteered. Said, our bar association would be very interested in this. We have no specific details and nothing to offer except to say we have the willingness to examine, just general language. And sent it back. Mercy alive. Wasn't but about a week or two, got a letter back from one of a guy named Irving Goldberg, like our judge in my court, from up in Milwaukee, I believe Milwaukee, up in that part of the country, and said, we would like to interview you. We're having a meeting in Washington in a week or two. Would you perhaps come up there and tell us what you might plan in order to do this? And I talked to my chairman and said, what? And he said, well, and we had something to do up there. And then I said, well, I got a problem. I got to go see DOJ about it. And he said, well, why don't you and Ray go on up there? I said, what are we going to tell them? Whatever you think you ought to tell them. Tell them we're interested and we're willing. I said, okay. So we go up there, and there's about 8 or 10 people who are making a play because they know there's going to be some money going to be put into this program. But they were all, except for one other bar association and us, these were kind of people who would be in the business of making money doing that, like insurance company types and all. Man, they had graphs and charts and all kind of stuff. And so it come to our turn, and call on us, and Ray said, you tell them. So I get up there, and we later laughed about this, Mr. Goldberg and I, because we served on the American Bar Committee together to oversee this program. And I said, I wish I could give you charts and graphs like I've seen here. I'm very impressed by them. We don't have any. All we have is a bar association in Shreveport, Louisiana, that's willing to try to put together a program. We're aware of the problem, and we're becoming increasingly aware of it, and we'd be willing to see if we could put something together that would be meaningful and we could all learn something from. And I sat down. Well, the program went to Oregon City, Oregon. Is there such a place as that? But a town in Oregon, because a member of the committee was from that town. And he had in mind that they were going to put the school teachers together for a group. And so they got picked, and we were back up. Report back up. They did away with the commercial people. Good for them. And, well, it wasn't but just a matter of a month when the Oregon program, we were notified they could not put the group together. He said, okay, Shreveport, you got it. And now there'll be some money available through the American Bar Foundation and so on, like $100,000 or something, and to do it. Well, boy, oh boy, now if this ain't something. So we had to sit there and late into the night, agitating over what would you have. And it came like a bolt of lightning to us at one point. I think Bob Donovan and I were the only one left in the room that night. I said, Bob, we were trying to make a list of all the things like a medical policy and provide a benefit for all the things we could think of a lawyer did. Impossible. Just slap impossible. Then he said, you know, listing is an impossibility, but categorizing is not. What do you mean, Bob said. I said, hell, what do we do? It's simple. We give advice and consent to people. We do paperwork for people, such titles, due instruments, prepare contracts, review contracts, so on. We litigate for people. What else do we do? And we could put something like major legal. Put something, you know. So we prepared a plan in which we said we would provide these benefits to our people. Advice and consultation, defined it. Office practice, wills, contracts, title searches, these where you don't have litigation, non-litigation types of matters. Litigation, trial and defense and plaintiff, civil and criminal, trial and appellate. Didn't take much to spell it out. And we put major legal to cover the expenses that go beyond the normal. You have a little major legal on the side, take care of that. Whatever you put into the program, that'd be whatever you put into the policy. You could put $500, you could put $500,000 if you. And we set that back, and we were kind of proud. At least we had something we weren't stupid about. Damn, whoop! They picked us. And they said, put it together. What? Put a program together and run it for 2 years. They'll give you $100,000 a year, whatever the money. Fortunately, you think about how things in life are, so much of it just depends on Parachiden, happenstance. I'd had a client who, that we become good friends, and he was the business agent, what do you call the leader of a union, for the Laborers Local 299. And he had just been complaining to me about, you know, you've told me a time or two that it's against the law to practice law. It's a violation of law to practice law, unless you're a lawyer. I said, yeah. He said, I do it every day. I said, we know that. People, it's a reality. It ain't DA ain't after you. No, I'm not talking about that. And a day goes by, somebody doesn't come to me and say, Mr. Henry, I got this problem. Or somebody will say to me, they did so-and-so to me. Or that. And he said, sometimes I send them to a lawyer and sometimes, boy, but usually they can't afford it. They don't make a whole lot. But they don't qualify for legal services. They're working people making a living. Damn, Henry. Your people might just fit right in it, but you got to put something in it because we had a requirement. There had to be a minimum input from the people. That made sense. We had put that in. American Bar later said, yes, that's a necessary input. But we didn't realize it. Maybe they copied us. I don't know that. But we had a 2-cent requirement, a 2-cent per hour work requirement. Isn't that a big thing? And he says, I've just negotiated a nickel an hour, in addition to a little pay raise for him, a nickel an hour to be paid to the union for benefits that will go to them. And I'll take 2 cents of that and I'll put it in this program. And boy, we worked that out. We did it, and we published the booklet, and what were we going to provide the service, and they got them all together down at the convention center that night, and it was a membership meeting, and they told them what it was special about. So people were there with their families, and they were just, that membership had maybe 575, a little less than 600 members, but with their families right at 2,000. Perfect sized group for what we were trying to do. We later knew, but we didn't know at the time. And so, boy, they damn near all out there, thinking back at it. And so I told them what was in the book, and I told them, you've got a lawyer. Because it was, the way we had it set up, you didn't have to sign up for this. You could go to any lawyer you wanted to. And we, of course, alerted the bar, and the bar was willing to deal with it. 1 or 2 lawyers said no, but the bar was willing to go with it. And they said, we ain't going to pay, but we're just going to pay minimum. Whatever you pay, it's fine. We want to take part of the test. And so I said, pick a lawyer, any lawyer you want in Shreveport, and probably okay in Bossier, check with us first. You take your book, and you get your legal problems taken care of. And so, boy, the very next morning, I love this story. The very next morning, we got an older gentleman out there near Benton. Guy drives up in a truck, and bluntly it says to him, and there'd been some press about the program in this report. Not a whole lot, got a lot later on, but there was some little press about now have a program in the Shreveport Bar providing lawyers for them for local to members and family members of Local 299 of the Laborers International Union. And so this guy drives up a truck. He says to this elderly gentleman, I've come to get the furniture. Come help me load it. And he reached over and he got the booklet we'd given him. And I ought to have copies of it here. I'm sure in my files I've got them. And he said, legal plan, Local 229, Shreveport Board Association. And he said, showed him that, he said, my union is that we got this lawyer plan, and I apologize for delaying you, but they told us if we had a legal question before we did anything to check with our lawyer. And I'll check with my lawyer this morning, and if he tells me that I'm supposed to give you the furniture, he'd assured a debt of his nephew. He'd signed a note for the debt of his nephew. Nephew had given a mortgage. Come and get his furniture. And they said, if we have a question, talk to our lawyer. I'm going to do that. And if he says, I'm certain, I apologize for delaying you, but if you can come back this afternoon. And then he called the lawyer. And the lawyer called me later. And I said, what'd you tell him, Louis? I said, what did that, excuse me, well, I must just use the initials. What did that SOB say? He said, help me load the furniture. You signed the mortgage? No, I signed my nephew's note. That SOB, you tell him to call me when he comes back. Don't you give him nothing. Then he called me to tell me that. And I said, boy, you underscore that. And the guy never came back that afternoon, or the next day, or ever, you see. But that was happening. And all of a sudden, we had a 2-year test. And we were watching everything. We were testing and we were reporting and finding out the types of usages, really testing the program to see how it would work, how much money it really would take. We knew the 2 cents wasn't going to make it. What would it really take, and what were the use patterns and so on. And it was a learning experience for all of us, American Boy included. And so in the meantime, American Boy appointed a committee to oversee this operation. I was on that committee, served for years. I'm a lifetime member. As a matter of fact, I got a piece of paper out there saying that. And we finished that 2-year test, and I was there the night, or was it 3 years? Excuse me for not remembering. I was there the night we were wrapping it up. And I said, we've now concluded the test. American Boys out of it, their money's out of it. But we've looked at this, and we know what it would cost to keep the program running the way it was. It was like a nickel. The most 6 cents, but like a nickel an hour. And you're free to continue the program, but you're on your own. But we'll be willing to work with you. And I've got a group of lawyers and members of the board are willing to now, instead of being the ABA's board for this, to be the board, and I'm willing to continue serving on it so that you can continue the program if you wish to do it. To surprise would be too strong a word, but in part, surprise. The leadership then said, we've talked about this and we want to take that ballot that I said to you. Do we continue this program or not? And on the ballot, have you used it? Check yes or no. Do we continue it? Check yes or no. And they did that, and they gathered them up, and they stacked them up, and we continued having a cup of coffee while it was. And I'm thinking to myself, I wonder. And well, we did it private. We did, for my insistence, I did not take a show of hands, because I was they said, well, we're not going to hurt his feelings, or whatever they might have think, but we do a secret ballot. Overwhelmingly, keep the program. And the surprise to me, a higher percentage, not by much because it was in the 80s, a higher percentage of those who had not used it who said keep the program. Wow. And I got it right now. And now, the last time I got in his stats, and it's been several years, because I went to speak to a group down in New Orleans. They were meeting people who were involved in prepaid around the country. Had 20 million people involved in prepaid programs.
I was going to ask you how extensively this had caught on.
It just exploded. And I remember I was thinking the other day, and I did right. There was a guy who was at the early meetings, and he really wanted to set up a company to do this. And he said, please be on my board. And I said, I can't do that. I'll be glad to advise with you and to share with you what we do. But I'm doing this thing for the ABA. No, please be on my board. And he was a nice guy. I liked him. I like him. And so he stayed after me. When we finished, he said, you finished with the ABA? Come on my board. Take 25% of the stock. I said, I don't have the money. He said, take 25% of the stock. Being on my board, that'll more than take care of it. I can say, the person who's got the most experience in this is on my board. And I said, and I thought about it. I said, let me meditate on that. And I said, I can't take advantage of that. Damn, I did this for the board, and I'm going to do this. So I told him no. Would you believe that 25% as of this past year is worth $5 million? God no. I just wasn't
Showing that business acumen we all
Oh, I
so
had
fond
that
of.
business acumen, boy. They had a report on how this the outfit out of Oklahoma had done so well, and said this stock was now had an equity interest of $20 million. So 25. Okay. Well, I wasn't meant to be rich.
I was asking you to talk for a little bit about your work on the Ethics Commission. I know that was very important to you.
Yeah, in the early 70s, I think it was about 71, the Louisiana Supreme Court asked me to serve. They don't ask you, they tell you. The Supreme Court appointed me to serve on the Committee on Professional Responsibility. That was the Ethics Committee for Louisiana lawyers. And I'm having to reach back, and I think it was 7 of us, maybe it was 9, but we were appointed to serve at the pleasure of the court. I was the first plaintiff lawyer to serve. That somebody had the idea that you couldn't have an ethical plaintiff lawyer, and that teed me off so that I made it known to a couple of justices that this is damned outrageous. Can't have an ethical plaintiff lawyer. Nick, this business about you got to be a defense lawyer to be honest. I just eat my damn lunch because I saw how many of them weren't. And so I was president of the Louisiana Trial Lawyers Association, and they asked me to serve on the Ethics Commission. I thought they would say, we'll fix your butt. And after I got some assignments, and I figured, yeah, they got even with me. The Ethics Committee had responsibility for all the lawyers in Louisiana, and responsible to look into any complaint against a lawyer, decide if it's something that you could deal with at that level, say quit that lawyer because, and stop, end of story, or get a little bit higher level, up until the point where you might go to the court and say to the court, this is very, very serious, we're going to have a hearing on it, and bring in the witnesses and develop a record, and then make a decision, and then take it to the court with a recommendation that he be suspended or disbarred. Stuff, right up to the top, or all that, or maybe just reprimanded. So we had all of that, and so had to get the canons and master that, and we were, if you remember, in the 70s, there was a lot of change at the ABA level, and they came out with a new set of, we had canons that we've been in motion since about 1911. We pretty much had mastered those. Then the ABA did theirs, modified some, and we've been adopted by the various states, including Louisiana, with some modifications. And then again, the ABA has changed it twice since then. And then that's entirely appropriate as you make changes to adjust to the situation. Well, the Ethics Committee work became very, very demanding. Let me tell you how things have changed. The first assignment I had, or near about the first, I may have had some before that, but the first meeting, and we were talking about things lawyer did. We got a lawyer did something up there in Shreveport. You got to handle it, Hank. What is it? Oh, well, bring him in. We're not going to go to the court with it. We're not going to have a hearing. But he has absolutely got to understand this is unacceptable conduct, and that if he does anything like this again, bad things are going to happen. Can you get that message across to him? I said, yes, I can. Let's don't go any further than this. Yes, I can. I know him, and he's not an unethical person, and he's struggling to make a living, working hard. Yes. Okay, now you get him. So I brought him in my office, and I lectured his butt. You can't do that. You bring disgrace on yourself. You bring disgrace on us. You can't do that. And if you insist, bad things are going to happen. I didn't. This is an accident. I called them, and I got after them when I saw this, and it wasn't something I did. I just swear on my mother's grave. You know what he had done? in the yellow pages, they had printed his name in bold print under lawyers, alphabetically. His name was in darker print, and we had to jump his ass for that advertising. Boy, have things changed?
Right.
Yay! Man, he promised never to do that again. Now we got whole page ads in those yellow pages.
Television and the internet.
Oh, and television and internet, but boy, things have changed. The ethics, we had of course had bad things happening. Some lawyers were doing bad things. Not nearly as many as people would think, but more than enough, where they did wrong to their client, and where they, not to the point of prosecution, or because of their influence in the community, the prosecutor wouldn't take it on, and the ethics committee would take it on. Issuing a letter of opinions, a lawyer would ask, can I ethically do this? And we did that. Served 7 years on that, including a year as chair, and argued most of the cases that reached the Supreme Court level for ethical violations. And then the Supreme Court of Louisiana asked me to serve on the ethics committee for judges in Louisiana, the state the Judiciary Commission, and I did that for the last year and a half or so before I came on the court.
What authority did that commission have?
Had the ultimate authority over judges in terms of the same thing like lawyers. You look at what the judge did, privately call him in. Can't do that. And if he says, "Nick," not very many had the guts to do that, because it's awfully foolish. You say "Nick" to that group, going to yick you to the Supreme Court. And the Supreme Court has authority to just lift you, and Louisiana Supreme Court. But just to have that commission looking at what judges were doing, because judges do wrong, you know that. You tend to get whatever happens, and some people are just not as good at people as they ought to be. Only a few, I have to say. Most of them okay. The present company excluded, of course. We took a few matters to the Supreme Court, but in the main, the commission was able to handle with the judges, except some of the New Orleans judges. They were breathing to themselves.
A colorful crew. Huh?
Colorful crew, I'll guarantee you. A colorful crew.
You've talked a fair amount about cases that you litigated in the state Supreme Court. Did you ever argue in the Fifth Circuit? Oh,
many times. Many times. But we had a lot of federal work, and of course, appeals to the Fifth Circuit, and I enjoyed it. I must say, for the first argument I ever had down there, I didn't know no better. I was a dummy. I had my argument prepared. They told me it was 20 minutes, and so I prepared 18, allowed a little for questioning, and I practiced that thing with a train going down, and I got it down. I got it right to that 18 minutes, boys, right down. And so I go before the Fifth Circuit. My first time before the Fifth Circuit, I'm in like my first or second year of practice. Lord have mercy, second to most. And there's the former chief who was so tough, Joe Hutchinson. And I'm ashamed to say who the other two judges were. I don't know. But Judge Hutchinson was up there. And everybody was scared to death of him. I wasn't scared. I didn't have enough sense to be scared of him. I've heard some stories about him since then. I should have been scared of him. But he's up there. And he was kind of like him. He'd taken senior status. He'd been chief judge. He was the first chief judge before they called him chief judge. And so, man, I don't get up there good. And I forget, what was it? Oh, yeah. I had Judge Pleasant had a client who went on a fishing boat out in the Gulf, a charter fishing boat, and 4 or 5 of them, and they were fishing. And they had a couple of drinks, and sometime in the course of the night, his client's husband, he represented a widow, slipped overboard and drowned. Okay? It's a sad situation, a well-liked man. And so they had in the estate, they had a policy with a life insurance policy, and it was a substantial amount for that time, like $50,000, I think it was. That's a lot of money back in the early 60s. And they had a double indemnity if you were injured and died as a consequence of an accident while you were aboard a common carrier. So, was it Mr. Harry or Mr. Locke, Judge Pleasant? One of them said, take this and put it together, make sure that charter fishing boat's a common carrier. So I did my damnedest, and we put it, the judge, he was either judge, or it was a trial judge. Was it Judge Dawkins or was it Judge, I'm not sure. But boy, he poured it out the boot that this wasn't a charter. Ha, ha, ha. Took an appeal. I'm going to fifth second with this thing. Of course that's a charter fishing. What are you talking about? A common carrier, man. What darn anybody with any sense knows that. So I got up there and I practiced my talk all night. And as soon as I stepped up, I'm Henry Politz, represent the appellant, and question. Man, and I answered this question and question, answered this question and question, answered this question and debated this question, and one or two of them that they asked kind of question was the easy question, and boom, boy, Chief Judge question, and I'm answering it best I can, and then he says, well, counsel, it looks like your time is up. In the meantime, the courtroom had filled up, unbeknownst to me, including a guy who I later came to have such a tremendous respect for, and in fact, an affection and love for, John Minor Wisdom. They said to Judge Wisdom, there's a young lawyer down there in the courtroom, but I'd be in the courtroom arguing before the chief, and he's going to have him in contempt and have him in jail. And wonderful Judge Wisdom was coming down there to intervene for me. Didn't even know me. Didn't know who I was. And he was in there. I later learned that. And so he was sitting in the back of the courtroom. And the courtroom filled up. The people from the clerk's office, to see they got a young lawyer is giving Joe Hutchison hell. They're arguing like hell. Joe Hutchison? He has lost his mind. And you come see. Boy, they just filled the place. I didn't know better. And so when he says that, I said, sir? I was shocked. I haven't had a chance to argue my case. I've been trying to answer your questions. He looked at the two judges, and he said, well, very well, young man, we'll give you a moment to argue. And he leaned back in his chair, and he gave me about 3 or 4 minutes. And so I summed it up. Okay, nice and easy. And then they turned to the I believe, Richard Switzer, a good lawyer here from Shreveport, and a good man, and fine defense firm. Mr. Switzer stood up and he said, Your Honor, we're prepared to submit on the brief. We'll answer any question that the court might have. And the chief said, looked at the two, thank you, Mr. Switzer, we have no questions. I'm thinking, yeah, man, he won't even argue as my ass boy.
For one.
Hell, I didn't get out the building good. It poured me out the boot. Those guys didn't know what a common carrier was. That's why I got on the court, so I could help them understand that, you see.
So you set the court straight on that. Did you ever argue in the Supreme Court?
No, I never did. I had papers before the big court, but I never made an argument. That's one of the things that I was hoping that I'd have a chance to do, but I never did. Never did.
We've talked a lot about your practice and some of your extracurricular activities within the legal field. I know you were also involved in a lot of community activities and political activities also. Any of those you'd like to talk about?
Oh gosh, we had most of the things that I was involved with in some way impacted back on the law. Entities that were involved directly, indirectly with the law, like the Rutherford House, a place for children that we need to be aware of and try to help keep them. They're already into trouble, but before we send them off to places where we're going to fix it in place, like penitentiaries and so forth, and we set up the Rutherford House back in the early 70s, and now it has, gosh, I can't tell you how many students are in there. We started with 10. Called it Rutherford House because a nice lady gave us a house on Rutherford Street, and we called the operation Rutherford House. Now we have, of course, several buildings. There were other things like that, but none that really come to mind.
Did you get involved in electoral politics?
Oh well, yeah, you got to do that. Election, I love that. I got involved in all sorts of, any election. The elections are challenges. I've headed up mayoral elections, gubernatorial elections, and had major major positions in presidential elections, responsibilities in the election process itself. That's why in 1976 I was an elector.
At the Democratic National Convention?
No. What's in the Constitution of who elects the president? I ask you a question, Neil.
Hey, I'm the interviewer.
People think that the president's elected by the votes of the popular vote. We know better than that.
We all learned a lot about that last year.
Yeah, the Constitution says that each state shall have a number of electors equal to the number of representatives and senators in the House.
So you were actually one of the electors for the state of Louisiana.
Yeah, and we elect them. And what we have on our ballot, I suppose it may be similar in other states. We had Democrat and the name of the candidate, and below that, however, the names of and we had at that time 8, of 8 potential electors. Then you had the other candidate, Republican, and the names. Then you had independent or whatever, and then the names. And so the people vote, but what they're voting for is those names. And in the early part of December, as the Constitution provides, you go to the state capitol and you meet and you sign a ballot for president and sign a ballot for vice president. And in '76, I was one of the electors elected for the Democratic Party, and I got to sign for President Carter.
He won the state of Louisiana.
Won the state of Louisiana. Won the state, not by much, but he won the state of Louisiana. And he got our electoral votes. And then later he gave me a job. Because, see, I gave him a job. Turnabout's fair play.
Right. At the beginning of our session, you talked a little bit about what you learned from the more experienced lawyers at your firm when you first started out. As you look back on your career as a lawyer and as a judge, any thoughts that you have for what young lawyers or middle-aged lawyers ought to think about in terms of setting their priorities?
I don't want to speak too negatively. I have a concern, and I think, as you may recall from your time here, I have either the strength or the weakness of seeing every glass half full, not half empty. But even from that standpoint, I look at the practice of law in the new millennium, in the new century, and the practice of law in the 50s and 60s when I started. And it's two different things. And there's been a significant movement from professionalism to business, to where too many of the younger lawyers see this as a way to make a good living, and that's the be-all and the end-all. When the reality is, this is a profession of service which has a necessary and an appropriate dimension that you make a good living for yourself and your family in the process. But you're not there to make money. You're there to perform services, and you get money as a consequence. But you're there to perform services. And that is not, I'm afraid, not what the average graduate of law schools are impelled by today. And that troubles me. But I do see a movement back toward it. And maybe it's just hope rather than reality. But from my discussions at law schools and talking to law students in the last 2 or 3 years, I do tend to see a little bit of a difference in attitude. But out there in the practice, Neil, it's just changed dramatically since the 60s to the late 90s and now into the new century.
I can say for myself, and I don't think I'm unique in this regard, the whole year I was clerking for you, it was always just so plain to me and my co-clerks how much you loved the practice of law and how you saw it as a vehicle for you to do good things for individuals and for institutions in the community. And I don't think it's any coincidence that so many of your former law clerks are out doing good things in the legal community and are teaching and working for the government and working for poor people and public interest organizations and not out there just for the money. And
very proud of that. I'm very proud of that, and we don't presume to think that it's because they worked here. We like to think it's because when we picked them, they were already disposed to do that.
I think it's probably a combination of the two.
Combination of the two.